Welcome to Law and Life. This is Shashank Mishra with eminent senior advocate of Supreme Court of India, Subodh Markandeji. Here are the following questions concerning about the earlier video on Uniform Civil Code which have been received from the viewers and their answers are being given by the Mr. Subodh Markandeji in the seritum. The first question on which was Shariat Act 1937 was enacted by the Central Assembly of British India. How did it apply for the people living in the princely states in 1947? When and by which law was the Shariat Act applied to the princely states?
I appreciate the question and the insight of the viewer in asking it. Yes, the Central Assembly, as the predecessor of Parliament of India was called, was an institution created or continued by the Government of India Act 1935, having power only to enact laws for the provinces of the British India. It had no power to make laws for any of the 500 odd native states. The Sharia Act, as it was originally enacted, did not operate in those native states or apply to any person there. And just see this. Initially, the Indian states were called Part B states in the constitution, and they had 40% of territory and 23% of the population of India. Now, later, several laws, including an act called Part B States Laws Act 1951, was passed to extend several British India's laws to Part B states. But Sharia Act was extended to Part B states through an act of parliament called Miscellaneous Personal Laws Extension Act 1959, which came into force on 1st of February 1960.
The second question we have received is instead of extending the application of Shariat Act to the former princely state, was it not logically appropriate to repeal it in former British provinces as prelude to enacting the Uniform Civil Code?
Logically, if the government of India was sincere at that time in enacting the Uniform Civil Code, it was an excellent idea to repeal the Sharia Act at that time instead of extending the operation of that act to Part B states. The reason is that Uniform Civil Code and Sharia Act are repugnant to each other totally. So even if by any mischance the Parliament had failed to repeal it, you see, by reason of the principles of repugnance enshrined in Chapter 1 of Part 11 of our Constitution, the provisions of Uniform Civil Code would have prevailed. So that's the answer.
So the third question is Uniform Civil Code contrary to the Constitution as alleged in the resolution passed by the Jamiat ul Ulema-e-Hind at Deoband on 29th of May 2022?
You see, nothing can be more fallacious. Provisions of Part 4, that is directive principles, are in the nature of commands of the founding father of the Constitution to successive generations of rulers, elected rulers. Now, it is true that the provisions of Part 4 cannot be enforced through the processes of the court. But as Justice O. Chinnappa Reddy said in UP State Electricity Board versus Harishankar Jain, they are, however, fundamental to the governance of the country and must always be present to the minds of judges. Addressed to the courts, they mean that courts have to evolve, affirm, and apply rules of interpretation that advance and not hinder the principles set out in Part 4. Therefore, vague reliance on what the resolution says calls spirit of the Constitution is totally misplaced. It should not be forgotten that Constituent Assembly rejected 5 amendments of draft Article 35, equivalent to present Article 44, and it specifically rejected uh, the proposition that rights of so-called personal laws are outside the purview of Article 44. This is diametrically untrue. This is wholly untrue. In the matters of marriage, divorce, maintenance, inheritance are all civil matters, and they are not at all covered by the rights under Articles 25, 26, 29, or 30 of the Constitution. These are civil matters. Matters falling under Article 44 are civil matters. They are not matters of religion. So we must, the very concept of the very concept of secularism is that you must differentiate between the civil matters and religious matters. So matters such as this, which are civil matters, then they have nothing to do with the your right to religion, because there is a long-standing, doctrine which the Indian Supreme Court has consistently followed, and that is doctrine of whether it is, you see, when applying whether a particular uh, uh, any particular part is covered by Articles 25, 26, 29, and 30, you have to apply that essentiality test. So these cannot be called essentially, these do not satisfy the essentiality test. We have referred to on this particular our channel to essentiality test in several matters like hijab imbroglio, and I think on uh, a uniform civil code also. So you see, these are not the matters of religion. These are matters which are essentially civil in nature, and therefore the the that what we are discussing, that is that resolution by that body of ulemas, is totally misconceived.
Yes, sir. And that was the last question, sir. And thank you for answering all the questions, sir.